start from there, and I will dive right into the constitutional questions. The application before you for challenging the empanelment of this bench addresses itself, my lords, to the powers of the Chief Justice under Article 161, 2A and B, that establishes the office of the Chief Justice as head of the judiciary and of the Deputy Chief Justice as the deputy head of the judiciary. And conversely, my lords, to Articles 163, 1B, that again provides that the Deputy Chief Justice shall deputize the Chief Justice and be the Vice President of the Supreme Court. My lords and your ladyship, it is now beyond peradventure, and again quoting from the CTS, that while counsel submitted that there may be instances of delegation, they ignored, my lords and your ladyship, that the law expressly provides instances or gives direction as to when the Deputy Chief Justice shall exercise the powers of the Chief Justice. And my lords, this is expressly set out at Section 5, subsection 2A of the Judicial Service Act, Cap 185B of the laws of Kenya. The Judicial Service Act expressly provides, my lords, that the Chief Justice can deputize, or the Deputy Chief Justice will exercise the powers of the Chief Justice in the absence of the Chief Justice. My lords, the CTS and my learned friend, Professor Gideon Mugai, referred to this. There are only two professors senior counsels here, so he must be correct. My lord, in the CTS, it is clear that the Chief Justice communicated to the Deputy Chief Justice that she would be away to Geneva, Switzerland, and Milan, Italy, between the 12th of October 2024 and 24th of October 2024.
This evidence from the bank.
It's in the bank. It's on record. It's on record. Senior counsel and my pupil master Paul Muite.
Keep your voice calm. Keep your voice calm. There's no need to shout. I was asking the court whether this material is part of the court record or whether it is evidence from it. That's all I was asking.
You taught me to submit.
And politely.
You taught me to submit clearly, and I'm polite.
You were actually his pupil.
Yes, I was his pupil.
Yeah.
My lords and your ladyship. It is
Your Lordship, it
therefore
is important that in my address to the court, I indicated that the respondents in that application did not file any replying affidavit, through which this material could then be introduced before you.
My lord, it is part of the record. The record.
The material which is in the court portal is part of the court record.
Yes.
Your Lordship,
If it is not on the court record, if the material is in the court portal, is part of the court record.
Your Lordship, there's
Mr. Ndegwa,
Just for good order, my lords, that we make progress. Then we know, because we access the portal through particular case numbers, in which case file is this material available so that we can just log in and be able to see it.
my lord, it is not in my place to start educating or demonstrate to my learned friends what file to look for. Because this is important. I would have had no other way of accessing.
Professor, can you just give us a reference?
Yes, I had.
For purposes of clarity.
Yes, my lord, 05, we have 3 cases that are consolidated. We have accessed the portal in E015 of 2024, a transmission from Claire Wanyama, and E014 as consolidated. We have this material and they're aware of it. We have even gone further, my lord, and served or passed on the communication to my land. It is in the public domain, my lord. We could not have secured this communication anywhere else.
Do you mean to say that what you are holding is filed on CTS?
Does
it happen
it is,
at
yes.
time?
It is in the, what I have here is a copy from the CTS with a reference from the Chief Justice Office. We only accessed it from the portal.
But our request was very simple, my lord. My request was straightforward. There's an internal memo we've just been given here. My colleagues are saying it's on the portal. If we knew the case number in which it was, we would have verified it. The other option would have been for my colleagues, like we are getting a particular application this afternoon, have they filed an affidavit to this document? Truth of the matter is that documents in the CTS have a timestamp, as my lady points out. The document we are having here does not have a similar timestamp. We're just saying, show us where it is so that we authenticate, then we make progress. It doesn't make sense to demean the rest of us when you're asked to authenticate. You do precisely that, you authenticate.
My lord, I can confirm that it is even in the physical file. This document, the physical file.
How does it?
So that my learned friends do not have it, or that they are shocked that the Chief Justice is not in the country, should be a point for response. They can respond and say, we saw the Chief Justice around. That's a point to involve. My lord, if I may upgrade my time, they will have time to respond. Yes, the judicial report.
My apologies, my lady. I also have a specific question. We want to know in which case file in the portal, because that's the submission my colleague has made, there's this internal memo. First, I want to know the internal memos are normally in the portal. I'll be glad to learn. But more importantly, in which case file is this internal memo so that we authenticate? That's simple. My colleague Zanu said it is in the portal. He has a duty to furnish us with the particulars.
We have indicated, my lord, that it is in the physical file, and I promise in the module specifically. Address the so that I can proceed.
Your Lordship, would you kindly give us a ruling on our objection?
Please, the applicants, when you are submitting, the respondents gave you time. Please just give them time to make their submissions. You are going to respond. There will be time for you to make a response.
My lord, the proceedings before you are in the public interest. They are in the public interest, and therefore the question of time and management, my lords, and the need for expeditious disposal of the application before you cannot be overstated. My lords and your lordships, time and again, my learned friends have submitted that whereas this court can sit at odd hours where it receives an application, that in matters as mundane as the current matter before you, that this court should have had this matter in the course of the day. Of course, no doubt, my lord, this court has moved to the electronic age where matters are transmitted through mail and through other forms. My lord, but most fundamentally, we are here to challenge ex parte orders, not inter parte orders, not orders given inter partes. And my learned friends therefore cannot speak from both sides of the mouth that where you are dealing with matters of the impeachment of the deputy president, such as this, that ex parte orders cannot be issued, yet they obtained ex parte orders that necessitated the filing of the application before you. My lord, what we are dealing with here is a removal under Article 145, and which the law defines as final under Article 145(7) of the Constitution. When therefore my learned friends submit about the office of the Deputy President, they seem to forget that Article 145(7) refers to the finality of the Act of Senate. And therefore, all the orders obtained under the subject, all the orders obtained under the subject of this proceeding, my lord, were obtained after the impeachment proceedings, after the act of impeachment. And it is therefore important, my lord, in the interest of all of us, that these matters are resolved expeditiously and timelessly so that this court can move to the next phase. And the next phase, my lord, would be dealing with the question of the next step. My lords and your lordships, it is clear that my learned friends do not want to proceed to that phase. And that is, we have all these multiple applications and the inability of the applicants to want to be confined to the question of time. They want to speak throughout the night. On our part, we want to sanitize this proceedings, my lord, and stick to the point that the application does not meet the threshold set out for recusal, because recusal is also a prayer in this. They have advanced no reason at all to want this court to recuse itself or to find that it was not empaneled in line with Article 161, 163, 52A of the Judicial Act. We opine, my lords, that this bench was properly constituted by the Deputy Chief Justice, exercising powers donated to her by the Chief Justice, unless they say that there's another Chief Justice. Thank you.
My lord, my lady.